Kody Johnson with iFIBER 1 News with continued coverage of the David Nichols murder trial. We're entering about almost 2 full weeks. Our coverage started back in July 19th with the opening statements. We were lucky enough to bring in a guest, Garth Dano of Dano-Gilbert Law offices there in Moses Lake. Garth, thank you for coming in, first of all.
You're welcome.
And one of the things that we wanted to try and do is not everyone gets a chance to spend as much time in a courtroom as someone like yourself.
Right.
And we only see trials, if it's the O.J. Simpson trial or if it's, some kind of a TV show. So we're going to have Garth go through a few of the elements that we've seen so far, kind of help weigh this stuff, and kind of give us an insight as to what's going on kind of in the background. One of my first questions, Garth, in early testimony, we've heard that there is no 911 tape. The neighbor across the street heard the gunshot, called 911. She couldn't testify to seeing anyone shoot Sage Munro, but there is no 911 tape. The other element, and I'm going to throw this in, you can answer overall or take this in these two parts, but there were shoe impressions in some fresh snow that day, and originally they had thought, at least the prosecution had thought, that those pictures were taken early in the morning before 9 o'clock,
Right.
And we found that they weren't actually taken until, I think, after 11 o'clock, if I remember the testimony correctly. The attorneys for David Nichols jumped in, and they seemed to really make a big deal of those 2 points. Can you help us weigh in on this? I mean, did they make more of it than it really is? Or could some of this stuff affect the outcome of this trial?
Okay. Well, Kody, first of all, thank you for having me on today. And as they say sometimes, I've had better introductions, and I'm just kidding with that. You asked a lot of questions there, and I'll just try to summarize some of those things for you, how I see it. First of all, a lot of things need to be said preliminarily. First of all, this town of Ephrata this is a very tragic thing that occurred to Sage Munro and his family, and being a member of this community and Moses Lake, it's a tragedy what's happened to him. Obviously, David Nichols is on trial for his murder. This is an important case here in Grant County. It's the longest murder trial I've heard of in terms of quantity of time that's going to be devoted to it. So it's pretty early in the case to arrive at what the jury may do, what not do, or what may or may not happen. With regard to, first of all, you asked me about the 911 tape thing. And as we talked about off the air before I came on, Kody, we talked about the fact that apparently the lead investigator in the case, Juan Rodriguez, who was assigned to the case, I don't know that he'd ever handled a murder investigation before. In Grant County, we have a process for the public, so they would know about this, where all of the radio traffic in Grant County is handled through what's called a MAC dispatch center, multi-agency communication center in Moses Lake.
Now you're talking about the air traffic between police officers, their radios.
That's correct. So any 911 call that somebody calls in asking for police assistance or help, such as the woman across the street from Sage Munro's house called in, that would be recorded, and that would be handled through that agency. In addition to that, any police response from Ephrata Police Department, the Sheriff's Office, the Washington State Patrol, or any criminal agency would that also be recorded and kept and preserved. They have a process here where, because of their retention policies, they only retain these tapes for 90 days or 120 days. The prosecutor's office knows that. The police know that. And apparently, and again, I say these things without hearing the whole trial, but what I'm understanding is that that was not preserved and wasn't kept. There apparently wasn't a request by the police department to preserve or keep that 911 tape. And the significance of that from the defense standpoint of the case would be that there would be a serious question, because they say that would be, there's very material evidence or information that may be on that tape as to the time of the call, what exactly was said at the time, rather than going on her memory now.
Yeah, because it's been 2 years.
Right, it'd be an exact...
We're talking about a crime that was committed December 29th of 2009.
Correct. So that's significant that was not preserved and kept, and the defense is that's just going to point to what they are going to probably tailor as sloppy police practice and failure to follow policies or protocols, and they'll use that to their advantage at trial to say, where is that? That creates more suspicion. Why wasn't this kept or preserved? The second thing you asked me about was apparently footprints kept in the snow, there are footprints in the snow in the crime scene area. And before we went on air, you and I discussed the fact that, like the viewers would see, from watching CSI or any other
Right.
program, forensic program, and they have a police investigation in a murder scene like this, they would cordon that area off immediately. The officers would be instructed not to go into other than the emergency people needed to go into the home to try to
Right.
rescue the person. But other than that, the police agencies involved should have tried to stay out of that area in order that they not contaminate the area. Nice word. So like footprints as an example with fresh snow, it would be something that they would want to try to find a footprint, hopefully, that would match the killer of Sage Munro, match up and hopefully find a shoe print. In this case, David Nickel. From the state standpoint, they'd want to get David Nickel's shoe, theoretically,
Right.
and match it up precisely with a footprint in the snow. Pretty compelling, maybe game-ender evidence if they had such evidence. The problem that's created here, unfortunately for the state, is that apparently the officer, I think it was Rechtenwald, when he went in, and he testified in his direct testimony that he did this at 8:30. He went out and photographed these shoe prints. But then in cross-examination, apparently, he didn't do it until 9 o'clock, or 11 o'clock rather.
Right.
And so the defense is going to make a lot out of the fact that there is a large gap of time, and I think they got him to admit there were a lot of other people walking around in the area. So there's probably a significant amount of contamination, and that's what they're going to talk about again in defense. The defense will, at the end of the case, to wrap this up to the jury.
So the short of it is, those two elements right there could affect the outcome of this trial.
Well,
I mean,
Right.
my original question is the defense making more of this than it really is, but it doesn't sound like that could be the case. It sounds like that could weigh in.
I think from an elemental standpoint, from a just fundamental, everybody that's watched trials know, in speaking to people on the street and people I come in contact with and jurors, a trial of criminal cases, the burden of proof is on the state beyond a reasonable doubt. So the defense, to the extent that they can create any doubt about who the suspect may be in this case, we'll get to that in just a minute, or create any doubt about how police handle their procedures, or bring into question how they handle their procedures, always helps the defense. And when that comes out in cross-examination, what I just said as an example of Rechtenwald saying he did that at 8:30, and then there's evidence that he really didn't do it till 11, that makes the state's case weaker, and it makes them look like they're not telling the jury the truth. And credibility is the essence of what it's all about.
Right.
Okay.
Now, over the last, especially this week, we've heard from the attorneys for David Nichols,
Right.
a lot of stuff surrounding Ian Libby, and it's been their contention from the start that David Nichols shouldn't be the one on trial. They're pointing the finger at Ian Libby.
Correct.
And really have come right out and basically said that.
Right.
Does that create a legal problem for the defense attorneys later on? Or is this common practice and, to go in front of the judge and say, this other guy is guilty, could, for instance, Ian Libby bring a court case against the defense attorneys for?
Great question, Kody, and I guess to try to answer it directly is that the last portion you asked me is Libby theoretically could sue anybody he wants to sue. Whether or not he'd be successful is another story, but the point is that in a case, this is unusual. It's not often in murder case, although it happens quite a bit. If we just take O.J.'s case as an example, the defense, of course, said that it could be somebody else, and that the police stopped their investigation. When they had O.J. as a suspect, they stopped looking. You remember all the shenanigans of O.J. In the media, sending out a advertisement. Does anybody know about the real murder?
Right.
Kind of silly, and we all have our opinions about that, how that trial went. But in this case, apparently the defense has, and the state has been apprised of this as well. There is direct evidence through apparently a witness that's going to testify, I understand, or has given statements to the prosecuting attorney and to the defense lawyers or their investigators, that Libby has made some direct statements. There's evidence in the case that he apparently assaulted a girlfriend. I'm just paraphrasing what I understand. Assaulted a girlfriend within about 2 months of the murder, and apparently made some kind of statement to the effect that I'm going to kill you just like I killed the other guy. And so the defense can argue that. And you and I are aware of the fact that recently the judge has ruled, has found that he's a material witness, Mr. Libby, to this case. And that segues into another question, but he's violated a court order. He was supposed to appear. The court ordered him to appear twice. He hasn't shown up. He didn't show up when he was supposed to this past Monday,
right,
to court. He was ordered to be in court. He was let go on basically a $1,500 bail, and was ordered to keep in contact with his lawyers and also to show up in court at 9 o'clock Monday morning. Did not do that. The defense says that Ian Libby had motive opportunity, was near the scene. They contend, from what I can understand, that maybe there was a robbery taking place, or a
home invasion,
either home
type
invasion,
thing.
or I think their theory is that there's maybe a break-in or trying to steal a gun or steal something, and Munro maybe caught him in the act, and that's how he was shot.
Right.
So I guess we'll have to see how that plays out. But with Libby not showing up and violating court orders, that's not good for the state.
And it kind of sounds like not having Libby available kind of helps the defense. I mean, here we got a guy that we've asked to come in. He's not doing it. And it kind of helps their statement that maybe Ian Libby is the guy you should be looking at.
Well, I think that, Kody, so the viewers understand, you've been reporting this, or if they've been watching the trial thus far, they're aware of the fact, and I haven't been able to watch it because of my job. I haven't been able to watch it.
You actually do have to work during the day.
I have to work during the day and do other things, but the defense has their position, and with regard to just starting out, their position is that since the state does not have a murder weapon, the state doesn't have a bullet. They didn't retrieve that. There's no ballistics to be analyzed to determine which gun was used to shoot Sage Munro, or whether it was owned by whom and where, right? So they're missing that. They don't have David Nichols at the murder scene. They're trying mightily to put him in Spokane by the testimony we've been listening to, some of that today, by his cell phone communications. But they really don't have him in Ephrata at the time yet.
That's, as I understand it, yes.
So they don't have a direct witness about that, so it's a circumstantial case, meaning the jury can consider circumstantial evidence as well as direct evidence, but they don't have any direct evidence that puts Nichols here with a gun shooting Sage Munro. So
right.
To the extent the defense can create doubt about where he was, what he was doing, and or cast the blame on Ian Libby or some other suspect, that's what they're going to do in this case.
Yeah.
and it's reasonable. And if you were on trial, that's what you would want your defense attorneys to be doing as well.
Yeah. Well, I kind of want to stick with the
Sure.
we learned last weekend regarding Ian Libby. It sounds like he's wanted for questioning or being investigated for some kind of a home invasion, burglary, and it was at the home of someone that the defense is intending to call in as a witness. And we've heard from Jacqueline Walsh through cross-examination, and before the trial got going a few days ago, when she approached the judge, I think it was on Monday, saying, we have an individual here who hasn't checked in like he's supposed to on Monday. We think he's involved in these crimes. We think he could be trying to intimidate a witness. And they've asked for the trial to be suspended until he's been located.
Right.
And she went on a little further to say, I have a concern about the safety of myself and my investigative team. Again, are they making more of this than it is? Or if you were having to defend in this case,
Right.
would that be your take?
Well, Kody, I can't. First of all, I can't speculate everything that's going on with what the defense is doing. Judge Spurline's been on the bench a long time. He's a very respected, regarded judge here in Grant County with a vast amount of experience. Jackie's comments or Ms. Walsh's comments, I think, should be perceived as real. What's the defense doing? This is really unusual. I think in all the 30 years I've been practicing law, I don't think I've had a case where a witness violated a court order, direct court order not to show up when they're supposed to show up. That may have happened once, but I'm not thinking of it.
It's not very
so
common.
It's very unusual. And apparently from the defense perspective, Libby is a bad guy or has done some things. He's assaulted people. There's evidence from their perspective that he assaulted his girlfriend. There's evidence that he just assaulted or did a home invasion, went into somebody's house. Another witness in the case went in his house. I don't know what happened there. There's no Ephrata police report yet, and apparently the prosecutor doesn't have it yet either. But that's a serious crime. That's potentially burglary, theft, robbery, assault, depending upon how serious it was, could be all 4 serious felonies that he's committed while he's a material witness and while he's out supposed to be on his best behavior. And so if a guy's capable of doing that and disregarding a court order, I'd be making a big deal out if I were the defense too, and I'd be asking the court to order the prosecutor's office to come in with witnesses, and apparently they did that with a witness yesterday from the Ephrata Police Department to describe to the court what exactly happened or what the allegation is, but there's no reports, and Judge Spurline made a discretionary call until there's a report prepared. The prosecutor's office hasn't done anything. I understand that there is an arrest warrant out for Mr. Libby's arrest.
Yes.
They haven't been able to locate him. I'm sure he's fled Ephrata a long time ago, probably after Friday night he probably left. But I think the defense does have some grounds to be concerned because apparently he went into one of their witnesses' homes. So very serious, and the court would have some discretion under, if it gets any more serious, it'll be interesting to see how Judge Spurline handles that, whether or not he would find that all the accumulated potentially missteps by the state or their witnesses may result in either a mistrial or dismissal of the charges, potentially. That's a last resort for a court to do, but that could be done.
Okay.
Hope I answered that directly.
No, that was great.
Okay.
Terrific. And like I said, it's hard for someone who's not, I watched my fair share of TV over the years. You catch the OJ trial, you catch CSI sometimes.
Right.
So it's nice to get a perspective from someone who's had your experience and success too, to weigh in on some of this stuff.
Thank you.
One of the other big things that we heard yesterday morning, the state was prepared to call Rex Lane to the stand to provide testimony.
Right.
And before the trial was started, they approached Judge Spurline and said, we've got the witness, but we've just learned that he is going to provide testimony that David Nichols actually requested or asked about
Him paying him $2,000 to commit a murder.
to commit a murder.
Right.
Now, the defense wanted to get a recess on that.
Right.
Can you walk me through this? I mean,
Okay.
it seems kind of like a
Well, let's do it this way. That's a good question, Kody. For people that aren't in our business, typically how a case is handled, from the time the prosecutor files a criminal information against an individual, say a charge was filed against you, Kody, your lawyers have a right to get everything that the prosecutor has. And typically, before the prosecutor files a charge, they have already got a police report, they've got photographs, they've got all the, hopefully, or most of the evidence, typically, that they're going to need to bring the charges and successfully prosecute somebody charged with a crime. Okay, and that includes witness statements, such as from Mr. Lane or anybody else. Okay, so they have to turn that all over to the defense. Then the defense gets an opportunity through their investigators or from the attorneys to go and speak with those witnesses and to check that evidence out, hire their own forensic people, hire whoever they want to look at to look at all of that. So in the case of Mr. Lane, as an example, as I understand it, he was interviewed by law enforcement and gave statements to them. He was also, as I understand it, interviewed by the defense investigator and/or attorneys, and he did not report to either one of those, either the law enforcement or the defense, this statement, this alleged statement that he's now making now that David Nichols told him, offered to pay him $2,000 to commit a murder for him. That's just coming out. And so the defense is just hearing it for the first time. They're well within their right to ask the court to exclude, first of all, to exclude the statement entirely or prohibit him from testifying to that fact on the basis of the state's failure to disclose that. The state has come back and said, we didn't know that he was going to say that. We haven't done anything wrong, Your Honor, so he's allowed to testify to whatever he wants to testify to, and the defense can cross-examine him on that. In other words, well, you didn't tell anybody about this till just now.
kind of seems like a big thing.
And it's
to
a
leave
huge,
out.
it's a huge thing to leave out, and it makes his credibility look very poor because that would be a huge thing. You expect a witness in his circumstance to have reported immediately, that he would have said, "I know David Nichols. Matter of fact, Nichols offered me $2,000 to kill somebody,"
Yeah.
and him failing to leave that out for 2 years, and then suddenly telling the prosecutor in the middle of the trial that
Minutes
this-
before he was
so
supposed to go.
the defense has asked for a recess until Monday, as I understand it, to find out about that and probably find out some more information about this witness, Mr. Lane. Has he ever made any kind of, has he done this in the past? What's his credibility? But, some background information. And then they'll be back again, I'm sure, Monday before he testifies, asking Judge Spurline to either prohibit him from testifying about that or allowing them perhaps to bring in another witness to say this guy is a liar,
Right.
to bring in a rebuttal witness if Judge Spurline allows him to testify. My sense of it is that Judge Spurline will allow him to testify, even if the defense comes up with evidence, unless they find out that he's directly lied about it. But I think the judge, because how this works in courtrooms is you could have somebody just dishonest as the day is long. There's credibility as 1 on a scale of 1 to 100.
Yeah.
But they're allowed to testify, okay?
Ah.
Because that is evidence. They can testify to a fact, and if that's what their testimony is, then the defense punches holes in the person's credibility.
That would be your job
and
to-
to tell the jury this person's not worth believing for these reasons.
Yeah, and ultimately, I mean, that's what it comes down to. It's the
I
jury.
hope I didn't
that
bore
you-
everybody with that.
No,
I hope that was
no.
clear as mud.
No.
Okay.
That was
All right.
that was perfect. If can you talk from the prosecution side and the defense side here, in light of that, how this has come down?
Sure.
And that additional testimony that Rex Lane was going to provide. from a prosecution standpoint, are you happy? Although the timing is really bad, are you still happy? Or from the defensive side,
I would, and the trial of a case is so, it's the hardest thing I know
is.
as a human being that I've ever attempted to do. So second guessing people, other lawyers, how they conduct themselves, what they do, what they call, is kind of silly in a lot of ways. And probably me commenting on some of these things would be perceived by people as silly too. But to add some insight to what you're asking me, as a trial lawyer, I would be very worried in calling a witness, and I don't know that I'd want to call that witness to say that, even if I knew he was going to say that, and it may be helpful to the case. I would have to decide: is it worth the risk to call him, knowing that the defense is going to beat him to death and his credibility is going to be zero? That's going to take away maybe from my case in even calling him as a witness.
and that's, yes.
And so again, I don't know what the state intends to do with that, but from a personal standpoint and how I would approach it, I always look at it that way. Is it worth the putting him on the stand and exposing him to the cross-examination? And
Sure.
I better get out ahead of him. I better get out ahead of the defense on that and ask him those questions about his background. If there is some dirt in his background and I'm going to put him on, I better probably get that out first.
Yes.
Okay.
Now, if you're working on the defense for David Nichols, how would you be having to prepare for that testimony? I mean, are you sending all your people out to get as much? I mean, it doesn't seem like a lot of time.
Right. Well, under the circumstances, and that's always what makes practicing law crazy at times, because you've already done a lot of preparation and you're preparing in a long trial like this, which frankly I've never been in a trial this long, so I don't know where I speak. I've been in 2 or 3 week trials and I guess a month, but to go 10 weeks is a long time. But you're in the middle of that, and then you got to always anticipate something's going to come up like this. But then the question gets to be, do I have a reasonable amount of time to fully investigate that, and have I had enough time to do it? And if I haven't, then that's all I can say to the judge. Your Honor, I've done everything I can, but the defense needs additional time to check out some additional leads, so we're going to ask for another 3 or 4 days or a week to see if we can find out some information that may be helpful to the defense and more information about this witness.
Yeah, okay. So, but do you think if they're set to have this person testify on Monday,
Right.
That seems like a short amount of time.
Right.
If you're for either side to investigate something like that?
Obviously they have a right, the defense has a right to re-interview him. Apparently he's here, so that shouldn't be difficult to meet with him and conduct an interview outside the presence of the jury and see what he has to say and when this came up and why he didn't report these things earlier, and did he tell anybody else about Nichols' comment? What's he been doing?
Right.
What's his criminal history and background? Has he committed any crimes since December of 2009 we should know about? But they'll have an opportunity to do that, and if they feel they haven't been given a sufficient opportunity, then they'll be asking Judge Spurline to give them additional time, I'm sure.
Okay. The attorneys for David Nichols have asked for the case to be dismissed, I believe a total of 5 times, and I don't know the background on any of that argument.
Right.
Now, we do know that there is, for the 5th time, they have put a request in to Judge Spurline, and early on he ruled that he was going to wait until after the prosecution's case
Right.
to hear that motion. Now, again, this is my ignorance of the legal system. Is that the way it's normally done, or do the judges take this on a very case-by-case type basis?
Okay. Well, for the listeners here, typically the defense, if there are motions before the trial commences, if the defense feels there's a legitimate basis for asking the court either to rule to suppress evidence or dismiss the case, based upon proper grounds. You just don't do that willy-nilly. Sometimes lawyers have done that, but typically, as I understand it, the defense has contended, let's just be specific. A specific thing I think they've said is that the state has failed to produce evidence or give them evidence of their entire case, which from the defense standpoint is, state, you have an obligation under the rules to provide us with discovery. In other words, give us the information you have that you're going to put on trial so that we can investigate that ourselves and know about that. If the state is not giving that information to you timely and you're just starting trial, such as Mr. Lane showing up, or them giving reports to the defense the morning of trial that they hadn't seen before, the court, within its discretion, has the power to either suppress or really hamstring the state and or dismiss if they find the claims the defense are making are sufficiently serious that they're going to deprive the defendant of a fair trial. And under our system, we talk about that a lot, about what a fair trial is and due process, and I think everybody has their own perception and think defendants have too many rights, and I understand that, but in our system, all we're doing, we want to ensure that there's a level playing field, that the defense knows everything the state knows going into it, and the state has they got the upper hand because they've known about the case, they've investigated, they've done all that. When they have the defense have an opportunity to have that information as well so that they can properly prepare and examine it. And so when the state doesn't produce that in a timely fashion, the defense is going to ask to dismiss. What you said to me lastly is that Judge Sperline could be asked by the defense to dismiss or suppress evidence before trial, during the trial like what's happened now, or at the end of the state's case, the defense can say there isn't sufficient evidence to take the matter to the jury and we're asking you to dismiss it now. Or, Judge, there have been so many mistakes made during the course of this trial and things that they haven't turned over and mistakes the state has made, we're asking you to dismiss that in fairness to our client.
And that's okay. So that makes sense. So it is kind of handled on a case by case. Each motion of this nature is case by case.
Certainly.
So I mean,
certainly, and every lawyers do this quite often, and we have. You would expect that is that most lawyers have tried a number of cases and they've argued suppression motions like this, and have a lot of legal research in their favor to support whatever claims they're making, and they submit that to the court periodically before trial, during a trial, and what they call a halftime motion, which is what at the end of the state's case before the defense has to put on a case if they choose to.
Can you briefly explain that part of it for me?
What's that mean?
When you said that before the defense comes and tries to make their case, there's a...
What I mean by that is once the state, if hypothetically here, if it's a 10-week trial, I assume that the state's case is scheduled to take 4 to 6 weeks. I don't know. I missed that part, so I don't know. Maybe
I've
longer.
heard it could be 5 weeks, could be 10 weeks, depending on how many witnesses are called.
Very well. So when I say halftime motion, that's a shorthand way of saying that once the state rests, in other words, they put in all of their case, okay, then the defense has a right to put on any witnesses or any evidence they have or present their case to the jury. So that's the halftime.
Got it.
Between the state case and the defense case.
Okay. Maybe we should take a quick commercial break here. We'll let Mr. Dano take a drink of his coffee here. We're going to be back in just a moment with more coverage of the David Nichols murder trial being broadcast live on iFIBER 1 News. I'm Kody Johnson. We're going to be back in just a moment. And welcome back. I'm Kody Johnson with iFIBER 1 News. We brought in a special guest this afternoon for the lunchtime break. We are planning to continue our live coverage of the David Nichols murder trial. With me again is Garth Dano, his law firm, Dano-Gilbert in Moses Lake. Mr. Dano is been practicing law for 30 years.
Hate to say that, that's right.
I'm sorry, that probably made you a little bit older than you want, but
It's all right.
but you have tried over 100 cases
Right.
in state, federal courts, all over the place. So I want to point that out. That's one of the reasons we brought in Mr. Dano, is to help us kind of decipher some of these things and some of the elements of this trial. I'm going to give you kind of a broad question here. What can you tell us about what's going on behind the scenes? We know that, there's been oftentimes the jury's been asked to leave the courtroom.
Right.
Does that happen a lot?
Yeah, right. Good question, Kody. I know that people in the listening audience have their own perception about what goes on in trials or how trials are conducted, and I think it's always useful because the courtrooms are open to the public, and I think I always invite friends, relatives, anybody that's interested in seeing how the court system works to come up. Most of it's very boring, as you would expect. It's kind of dull, a lot of it, not a lot of excitement. But to answer the question specifically, during the course of a trial, as the viewers have seen in this case, Judge Spurline has excused the jury repeatedly. Typically that happens, not a whole lot, but it depends on the lawyers and the objections made. But the court does not want to have the jury hear why the lawyers are objecting to certain evidence coming in or staying out. For example, if a witness is testifying and the state has an objection to that witness is saying something, and there's been a court order the judge has already ordered that witness X, Mr. Lane, not be allowed to testify to something. And they've gotten up to the point in the trial, and then one side or the other says, Your Honor, I'd like to be heard on whether or not I can ask that question, whether I can elicit or get that answer from that witness. Then Judge Spurline will excuse the jury, so they get their exercise in and out, and they go back in the jury room. And then the lawyers, as the viewers have seen, listen to the lawyers argue at that point, and then Judge Spurline makes a ruling whether or not he's going to allow that witness to testify or not testify. The jury's brought back in, and he either tells the lawyers before the question is asked whether that's going to be allowed or not allowed. But they don't want the jury to hear that. And the thing that's frustrating for the viewers and the public is they say themselves, like I would, well, they don't get to hear the whole thing.
Yeah.
The juries aren't hearing the whole thing. Well, like everything else, there's admissible and inadmissible evidence. And sometimes there are very legitimate reasons why the jury should not hear certain things or should hear certain things. And the judge is a gatekeeper, if you will, and he's making the ruling about what's going to come in and what's going to stay out. And until he rules, just like a baseball umpire making a call at first base, until he makes that call, we're waiting. And the jury necessarily the public can disagree with that. As lawyers and people familiar with the system know, it's a real important function for the court to exercise to keep evidence out and for the jury not to hear inadmissible evidence. Because they may hear something, if it didn't happen that way, a case could be decided based upon something they shouldn't have heard.
Right.
Okay.
And so that makes sense. So this does happen quite a lot then. I mean, you would expect
it's fairly typical.
Typical?
Fairly typical in a long trial, and depending upon the experience of the lawyers and depending upon, it's serious. Everything's serious in a murder case because let's just say it. There's a tremendous amount at stake. This isn't a DUI trial or maybe a civil case.
It's not a jaywalking.
Where there's not life or death involved. So the judge wants to get it right. And given a reasonable opportunity by the lawyers to give him the law and the facts and for him to do an analysis to make those calls during the case. Okay. Judges don't like it, by the way. Judges do not like when something's brought up as a surprise to them in the middle of a trial with the jury there. Yeah. When they haven't had sufficient time to think about the issue, research the issue, satisfy themselves that they're correct in their ruling. Judges don't like to make errors. Yeah. And I forgot to tell you one other thing earlier, which is defense lawyers, this probably won't come as a shock to the viewers either, but when they handle a case, they give the court a lot of opportunities to make a mistake. And
right.
And for the for the reason.
I'm with you.
So they'll bring up and have an evidentiary issue, and the judge may make an incorrect ruling. That's why we have courts of appeal and the Supreme Court. So that's why you see sometimes a trial take place. Everybody goes, well, the guy was found guilty. Why are we having an appeal? It was shut. It was open and shut. Well, the defendant has a right to appeal and to ask the reviewing court, either Division III of our court system in Spokane or the Washington Supreme Court in Olympia to rule whether or not Judge Sperline maybe made an evidentiary error in either prohibiting evidence from coming into the trial or allowing evidence to come in that he shouldn't have. In either case, they can say that the judge made an error. It resulted in an unfair trial for our client. We either want a retrial or dismissal. I hope that's clear.
That brings another question to mind.
Sure.
If you're presiding over this trial, are you doing a lot of homework?
Nobody'd let me do that.
No one would let you do
Nobody would let me do that. The state definitely wouldn't let me do that.
I mean, most people think of a judge, I mean, they just go up, they sit down, and they listen to stuff. But that's not how it works. I mean, judges often are having to do their own research, like you kind of hinted to just a little bit ago.
Well, a good judge, and Judge Sperline is an excellent judge, would, they take their job seriously, and no one likes to make a mistake in anything they do. So judges don't like to make off-the-seat-of-their-pants rulings if they can be aided in advance and think about it. So what they prefer to have, of course, is if an issue such as this one with Lane, let's focus on that, comes up with about him going to testify or not about certain facts, they'd like to know about that in advance. They'd like to see if there's what's called legal precedent, whether or not there's a case that was handled similarly in another county or within our court system, within our appellate court or by the Supreme Court, in which the court handled a similar issue in a similar case and gives some guidance to the trial court, Judge Sperline, as to how he should rule with that evidence. What his parameters are, whether it's a discretionary thing, he can make a call based upon it right now, or whether there's some legal authority that directly says that's not allowable.
Okay.
And they like to know that.
Another question about the jurors.
Sure.
Early on, we lost, I think, one, maybe two jurors. Is that typical?
No, that was a bizarre thing.
Okay.
I'm aware of the fact that, and again, I'm speaking. Well,
I should
apparently-
say for the public,
Sorry.
what it was, we had a juror that just didn't show up, at least one, I believe. Maybe it was two.
Right.
And they had to have alternates come in.
I'm aware of the one circumstance where the jury was impaneled. In other words, the lawyers had gone through their selection process, and the court had put the 12 people in the box that were going to sit as a juror in this case, and for some reason one of the jurors didn't show up.
Yeah.
And with no call in to the clerk's office or to the court to tell the judge, I'm whatever.
Yeah.
I won't say anything smart, but she didn't even call in, or he didn't call in, or whoever didn't call in. And so that's why the court, because this is such a long trial, had 6 alternates. That's unusual. But with the length of the trial being 10 weeks, a 10-week trial, knowing people's schedule and knowing that emergencies may come up for some of the jurors, some of the actual jurors. They could have a death in the family or something serious catastrophic happen to them, and they may need to be excused as jurors. So you got the 6 alternates. One of them takes that place. So in this case, that's already happened once, if not twice.
Yeah. And I could be wrong. Maybe it was just the one time.
Okay, I think it was just once, but
Yeah.
okay.
Okay. Now, is this a hard thing for the jurors? I mean, if you're sitting on this jury panel, and you're looking at a long trial, it's a murder trial, yes.
Right.
But, does it wear down a jury when it's this long?
I've never sat as a juror, Kody, so I can't speak intelligently or competently about that. I would say to you, I think lawyers forget that sometimes, how boring they are and how much they bore jurors to tears, But I would think it'd be very difficult to sit for that long a period of time. I really do. Frankly, we know from all the studies on this that juries have, just like you and I do, I'm getting older now, so I have limited capacity, but have different capacities. And frankly, during an all-day trial, as a lawyer, I'm probably saying to myself, I'll be happy if the jury retains 20% of this. In a long trial, there's a real danger of the jurors losing interest, getting bored to death, not paying attention, mixing up the facts. So you got to find ways to keep their attention. So I would think that it'd be a tough one, although this jury hasn't been sequestered.
Right.
And for the listening or the viewers watching that just means the court would have discretion if he felt it was appropriate to have the jurors stay at one place in one hotel or one area. They're allowed to go home at night. So they got that going for them, so it's not so bad. It could be worse.
Okay. Now, these jurors had to go through a selection process.
Right.
And can you walk us through that part of it too? I know you've had to do this. That whole process of being selected as a juror or an alternate. Is that something that takes a matter of minutes? Or is it, are these jurors having to sit there for a long time? And what's the dialogue between?
Okay. Well, Kody, to answer the question directly, typically what happens in Grant County in most courtrooms is the jurors, have you got a jury summons?
I have.
Okay.
But
and you had to fill out
I filled it out and haven't heard anything back yet.
Okay, well, thank goodness that happened for you. But basically there's a form that's filled out, and of course as a defense lawyer or doing civil cases that I handle, I usually submit or ask the court to broaden or lengthen the jury questionnaire.
Okay.
So that I know more about the prospective juror. So if I wanted to know about Kody Johnson, I want to know some things about you from a defense standpoint and a prosecutor standpoint, because they want to know, are you the kind of guy that wants to hang everybody, or are you a bleeding heart that thinks nobody's guilty of anything? As
Sure.
two extreme examples. Are you somewhere in the middle of that? And I want to find out a lot about you. But we don't have the time because the courts limit the amount of time the lawyers can ask questions of jurors. And the thing that's missing in our system, if you will, to me, is trust. We're asking the jurors to perform a vital function and to trust the lawyers and the court. Well, that's impossible. When you tell the lawyers that you've only got a half an hour or 2 hours to talk with 100 witnesses or prospective jurors, that's silly. Now, in this case, that process took longer, no question. But in a typical case, it's the courts are taking an approach that they think lawyers are boring people to death, the prospective jurors, so they're trying to cut the lawyers off from asking questions, which I think is wrong. I'll just tell you that.
Yeah.
For
any case, or
I think for any case, I think that it's important for both lawyers in trying a case to feel like they know jurors. I tell jurors now that, I'm always told that the biggest bunch of liars there are lawyers because their lips are moving, right? And
Okay.
But I always tell jurors now that I'm finding that the biggest bunch of liars I know are prospective jurors because they don't tell you because they're afraid. They don't want to talk publicly.
Sure.
They're terrified. Nobody likes to sit in front of their peers and speak audibly because they haven't been trained to do that, and it's terrifying. And they don't want people knowing their personal business.
And it sometimes comes up.
And the thing that's missing in that process then is that the lawyers can't make an informed, intelligent decision about somebody because somebody could be on one of those extremes I just said a minute ago, but the lawyer would never find out about that, so they can engage in what's called a peremptory challenge. So all that means is a long way around the barn to say that some jurors are excused because they got personal reasons, family commitments, other kind of commitments. In this case, like there was 160 or more jurors that were brought in, a lot of jurors, because this is a 10-week trial. And a lot of them were excused for personal reasons ahead of time out of that group. And of the group that was left, then a number of jurors were excused for what we call cause. In other words, in the questioning done by the lawyers, something came up, they made some kind of statement, they'd heard about the case, they had a preconceived idea about the case, and so they're excluded for those reasons. Then after those reasons are exhausted from the remaining people that were left, then the lawyers had a right to exercise what are called peremptory challenges, where they don't have to give a reason at all. They're just simply, I got a right to excuse juror number 12. I don't like how she looked at me or something like that. They can exclude that, and they get 6 of those apiece to get down to the 12 jurors you have left and the alternate.
And the alternates,
Sure.
yeah, okay.
Sure.
I'm going to give you a hard question now.
Okay.
Okay, I think you're doing great.
I'm
and
sitting
I
down
wanna
for it. I'm
thank-
sitting down for it.
I want to thank you again. This is terrific insight information into our legal system,
Sure.
and in particular to the trial. And you may not have a good answer for this because I'm going to ask straight up.
I'll give it my best shot, Kody.
Okay, I'm going to ask straight up. I mean, do you feel like there's someone's winning in this case, the prosecution or the defense, or is this a question that I shouldn't even bring up until way later on?
Well, to answer your question, I think it's obviously it's a legitimate question. I don't think there's any silly questions, and that is fair. I would say to you, I think it is premature probably until we hear more. I think that the defense has some very they might have a few more reasons to feel better about themselves than the state does at this point, given what's gone on. Because again, it's the unusual
Right.
part about having a material witness flee and that occur after trial. I've not seen that or commit a crime. That's bad for the state. There's some other things that have happened that I don't think help the state's case. But it's too early to tell because we don't have I haven't heard any of this direct testimony yet about what the calls were that went on, threats that maybe Mr. Nichols made, motive opportunity. Those things haven't been developed fully, so it's probably premature to answer that. I think he asked me a second part of that, and
Well, you did a good job answering.
Okay.
Really, and that's kind of was my feeling. Having watched a lot of this trial,
right.
I'm left thinking, there's probably some highs and lows
Right.
For the prosecution.
Sure.
But it seems to me there's still a lot of evidence left to present.
A lot of evidence and a lot of things that are going to come up yet, and you never know. I mean, trials are like kind of by metaphor, are like a heavyweight boxing match, really. I've been in longer trials. One day you feel great, you feel like you're winning, everything's going well, the evidence is going in well. The next day you get kicked in the gut, and you're down, and you got to kind of brush yourself back up, and you don't know quite what a jury's going to do after they hear everything anyway. So I never think that I'm in any cases in the bag, as they say.
Yeah.
The burden of proof is beyond a reasonable doubt in a criminal case, and that makes the burden tough on the state. And so if there's doubt about Nichols being the murderer in this case, that's obviously good for the defense, and there's some things that have been raised so far that are helpful to them. But again, it would be premature to talk about it.
Well, let me kind of reformulate the question just a little bit. From the attorneys for David Nichols, do you feel good at this point? I mean, based on the evidence that's been presented and your cross-examination?
I don't think, Kody, I would say to you that any lawyer that tells you they feel good, I don't know. I need to see their therapist, because I never feel good during the course of a trial. It's very difficult. Even if things are going as anticipated or going what you would say your way, or you're not running into things that are necessarily bad for you. Your anxiety level is always maximum.
Yeah.
And so I would think that from the defense standpoint, certain things that have happened thus far in the trial, certain things that are being said, their ability to create some error, if you will, by the rulings that Judge Spurline is making, and their ability to present some things so far, have got to make them think they got at least a fighting chance.
Yeah.
A lot of most criminal cases are pretty open and shut. There's, if, as an example, in this case, if the state had a murder weapon,
Or ballistics?
or ballistics, which they don't have, or they had Nichols for sure in Ephrata, near the home at the time of the murder, and was seen fleeing there, or something like that. That's pretty compelling evidence that would make anybody say, well, it looks like it's pretty open and shut. But they don't have that, and they're trying to prove it other ways, which makes their job much more difficult
Uh-huh.
than the typical case that the prosecution puts on.
That makes sense. Is there anything else that that's any other elements of the trial that have been surprising for you? I know you haven't been able to watch all of it.
Right.
I do know that you have been in court watching some of the trial, and you've watched some of the broadcasts that we've done.
Right. Well, I had to be up in Ephrata, and so I've popped in and watched a little bit of the trial and heard a few of the motions. And
Uh-huh.
and thanks to iFIBER, this is excellent. I appreciate this being shown to the public live. I think that's excellent, so that people that can't get here can watch it if they choose to. So I think that's awesome. I have watched parts of it, and I think that you asked me earlier what's going to happen if Libby testifies or doesn't testify, or if Nichols testifies or doesn't testify, and that really that's going to be pretty important to the defense and the state. If Libby is not found and doesn't show up and doesn't testify, they're going to be the defense will make a lot of that. And even if he does testify, the defense is going to make a lot of that.
Yeah.
And as far as Nichols is concerned, I'll be surprised, frankly, if they put Nichols on. You know, most defense lawyers, if they feel there's sufficient doubt that's been generated or raised in a case, speak to their client. The client ultimately has the right to testify and to make the call to testify over
Sure.
the advice of their attorney. But you know, if the case proceeds, and let's say there's a lot of doubt, especially about Mr. Libby and some other things that happened, and it looks like it's a 50-50 call, then I wouldn't expect the defense to do much by way of calling a witness. They may call some rebuttal witnesses if they have to,
Uh-huh.
but that's how I'd see the thing going. And again, that's premature for me to say, because again, I don't know everything.
Yeah, I've heard a lot, you know, just from TV and news. Attorneys don't like to put their clients on the stand, especially in something like this.
Right.
Is that generally speaking because, you know, we're not prepared, you know, as normal people
Right.
and to take the stand like that.
Right.
And it could be just that we don't come off quite right
Right.
to the jury.
Right. Well, I say to answer that question, Kody, I tell people that in jury selection, typically ask jurors about that, if they have ever thought about being a witness, and most of them are terrified at the prospect of being a witness. There's a big difference between coming into a courtroom and being able to sit in the background.
Right.
But when you're the focus of the trial, and you got a judge sitting up there and 12 people looking at you, and some lawyer you don't know, and you don't know what they're going to ask you, and it's serious. And when you know, as an example, police officers in their training, they spend time at the patrol academy learning how to testify.
Right.
To be testifying witnesses. They actually take them through classes. Now, you would expect, of course, lawyers spend time with their clients or with witnesses in advance of a trial to ask them questions, see how they're going to answer. But nothing really prepares you until you get on the stand. I've seen witnesses totally freeze up, just so overcome by fear
Uh-huh.
and
Yeah.
terror at being on the witness stand that they couldn't talk, or they blurt out some answer that's not at all what they've told you, and you know, you're left with,
Wow.
wow, I wouldn't expect. I usually got to impeach your own witness. In other words, you've got to. I've had that happen where I've had to say, well, isn't it true that we talked about that and you gave me this
Yeah.
answer? I was so surprised by the answer you just gave me, and have the witness go, oh, you're right, I don't know what I was thinking, but that doesn't look good. So
Right. Right.
you're not worried about the questions you're going to ask them. What you're worried about is how they're going to appear when asked questions by the other side.
Okay. Well, is there anything else you'd like to add? I know we've got a couple minutes here left. If you anything else that you can tell us about the trial that, or how this trial is being conducted, might be something that our viewing audience isn't quite aware of?
Well, I think that one thing I would just make an observation as somebody who has lived in Grant County and is a member of the public. I'm glad that the viewers have an opportunity, to the extent that they're going to use it and watch this trial, that they take advantage of that opportunity to do that. I think it's helpful for them to know how the system works.
It's been very interesting.
And
I've learned quite a lot myself.
And so I think it's always educational that way. I would say that it isn't perfect, but it is good. And not a criticism, but something that the public needs to know about is just the burden that this places on the system. Everybody wants, I hear this a lot from the public, well, these criminals are getting out and all these things are being committed and people are getting off, and OJ as an example or somebody else, it's an aberrational case, meaning that it's unusual. And so from my perspective, I don't know what the statistics are, but 99% or 95% of the people being charged with crimes are convicted or plead guilty. So the system's not breaking down. The fact that somebody may be found innocent of a crime that the public would think that they're guilty of based upon what they read in the newspaper or Uncle Joe told them on the street.
That's what hits the newspapers.
Right, and so they think the system is broken, and I'm just going to say it's not. The only thing that we need in this county, probably from my perspective, would be maybe another judge and a couple more courtrooms, because our civil cases suffer.
With the load?
Yeah, with the tremendous load that the criminal trials taking precedence over civil trials because criminals have a right to be tried within a certain period of time. So their cases take precedence, and our civil trial calendar is getting shoved to the back, which is a big problem here in Grant County.
Well, I understand we've got correct me if I'm wrong, but don't we have a new judge coming in here soon?
We have that's for district court.
Okay.
And this is for the viewers. Our court system is broken up in Superior Court. Superior Court handles like what we're in right in this forum we're in right now with Judge Sperline. He's a Superior Court judge along with Judge Nodell and Judge Antos. Judge Whitener-Moberg and Judge Fitter are our district court judges, and we're going to add the legislature allocated money, and the county's going to build another courtroom, I think, for a third district court judge, and the district court judges handle misdemeanor offenses, a lot of traffic and that kind of thing. But we're limited with the Superior Court to 3 judges right now.
Okay. Again, I've got Garth Dano with me, practicing lawyer for over 30 years, graduate of Gonzaga University. He's handled over 100 court cases in his career, federal, state, inside Grant County, outside of Grant County. Garth, I want to thank you one more time.
Thank you.
And you've done such a wonderful job on live TV. I'm going to put you on the spot here, and I'm going to invite you. I know you're a football fan.
I am.
I'm going to have you come and help me call some football games.
That'd be my pleasure, Kody. I'd look forward to that challenge.
All right. Well, that should be nothing compared to being in court. I mean, good grief.
Well, we could hope not. But it may be. Anyway, I appreciate you having me on today and have an opportunity to speak to you about all this, and maybe we can do it again as the trial progresses on.
Thank you so much. And I guess we're kind of coming in. We got maybe about 20 minutes, I'm going to guess, until court resumes. From the studio here at iFIBER 1 News, I'm Kody Johnson for Garth Dano. We will catch up with you again. We've got our camera crew set up right now in the courtroom, and we're going to be switching over to them probably in about 15 or 20 minutes, I'm guessing.